Welcome to everyone who's joining us today. It's great to see all of you there, and we hope that the information we provide today will be of use to you. I'm going to kick off and go through some topics, and then I'll hand back to Imran, who will talk to you about some other areas that we think might be helpful for you today. So first, I'm going to start with some general tips for co-parenting during COVID and the pandemic. I would say the best thing to do is to be open and honest with your child's other parent, and try to keep the communication lines open. Talking about things can often stop matters escalating and stop misunderstandings from happening. Obviously, the government guidance is that if you or your child have symptoms, then you have to self-isolate. Now, I know that there was a question that came in earlier about a parent trying to use self-isolation to kind of get more time with the child, and that's really not okay. And if you have to self-isolate with the child because of COVID symptoms, then if at all possible, time that the other parent has missed ought to be made up, and it should be made up if you can at a time that's convenient to that parent. Also, there's been, fortunately all the children are back at school at the moment, but homeschooling has been a massive thing during the past year, and the difficulties that people have faced with that. It's the responsibility of both parents to help the children with homeschool, help them access what they need to, just as you would help your child with homework if they were going to school normally, which for the moment they are, and hopefully it will stay that way. Another thing that people have been concerned about is children moving between vulnerable households. Risks can be minimized by spending as much time outdoors as possible, regular hand washing, regular cleaning, sanitizing. Just because one household has a vulnerable member or contact with a vulnerable member doesn't mean that the child shouldn't be able to move between two households and enjoy a good relationship with both of their parents. That's really important. With the success of the vaccine rollout, most of the vulnerable or elderly people in the UK have now been vaccinated, so hopefully that alleviates some of those concerns. If you care for a vulnerable adult or are in a bubble with a vulnerable adult, then it's your responsibility to manage the risk as best you can. It can't be used as an excuse to prevent your child or children from seeing the other parent with whom they'd normally have contact. A question that I'm often asked, and again was in some of the questions that we got in advance of this webinar today, was what do you do if one of the parents isn't following the government guidelines? This is really tricky to deal with. If at all possible, the best thing to do is just have a conversation with them and sort of set some expectations about how you think they should be behaving around the coronavirus pandemic and following the rules. Obviously, it goes without saying that you should be doing all that you can to follow the government guidelines when you're by yourself or with your children. It is important to distinguish between guidelines and rules. Obviously, the rules are the rules, they're the law, but the government has put out a lot of guidance during this pandemic, which is open to interpretation. And people do often have different interpretations of the guidelines, depending on their particular situation or their anxieties and fears around COVID. Provided that the other parent is obeying the law, you can't refuse contact on the basis that they're interpreting the guidance perhaps less stringently than you are, because it is just guidance. Often the parents that I speak to who have raised this issue with me have heard from some third-party source that the other parent is, mixing with households when they shouldn't be, or letting somebody in their house, or traveling in a car when they shouldn't be. And the information's all coming from a third-party source. You might not have all the facts, or they might be breaking the rules, but you also might not have all the facts. So if you're going to bring that up with the other parent, try to approach that conversation openly without making assumptions or accusations, and ask for their version of events, because that might help the conversation go more smoothly. If you do choose to refuse contact on the basis of the other parent's behaviour around the COVID rules and not following them, and this only applies if you do have a court order in place, It is open to the other parent to then issue enforcement proceedings at court to enforce that court order, and the burden of proof will be on you to prove that they have been, not following guidance as they should have been. And if the court doesn't believe that you were right in stopping the contact, it is open to them to impose fines or community service for stopping that contact. So kind of right back at the start, I said communication is key. It is the best way to deal with all of these issues, is just talk to the other person, find out where they're coming from, try to understand what's going on, and move forward that way if you can. COVID has impacted people's financial situations, and this can cause issues in respect of child maintenance. Child maintenance is dealt with by the Child Maintenance Service, and if your income has changed, you can contact them to find out how much child maintenance you should be paying. Similarly, if you believe that you're not being paid enough child maintenance, again, you can contact the Child Maintenance Service about that. Their website is really helpful. It has a calculator, and you can put in income and how many overnight stays the children have with the parent that should be paying maintenance, to bring up a calculation of what they should be paying you, or if you're the one that's paying, what you should be paying to the other parent. The best way to deal with child maintenance is to try to sort it between yourselves, agree the figure, and then always send it by direct debit through bank account, so there's a record. Would never recommend just paying in cash, because there's no evidence that maintenance has been paid or not paid if you do it with cash. If one parent's being really uncooperative and not paying, then the Child Maintenance Service can go directly to their employer to take the maintenance away. I've just seen a question pop up about maintenance if another parent lives abroad in the EU, and that's something that you'd need to contact the Child Maintenance Service about to get an answer for that. The courts don't deal with it. The jurisdiction for child maintenance is with the Government Child Maintenance Service, and when we're asked questions about maintenance, we always point people to that service to call them and get answers. And the last thing I'm going to talk about before I hand back to Imran is changes to the financial orders due to the impacts of COVID. I know this webinar is about children, and finances does play a part, obviously, in bringing up your children. So we're just going to run through this really quickly. So when you've got a final financial order made by the court, either by agreement between parties or by a decision of the court, and it's been sealed, it's final and binding upon decree absolute, which is the final stage of your divorce. If a party wishes to make an appeal against a financial order, they've got 21 days to do so, and can only ask the court to revisit the terms of the final order in very, very limited circumstances. Such circumstances have to be either where it can be proven that there was a material non-disclosure by one party, or a significant mistake, which would mean the final order was no longer fair or just. The court can exercise discretion in allowing appeal out of time, so after the 21 days, on the grounds of a new event, provided certain criteria are satisfied. In the legal world, we call these new events barter events. A barter event is something that is unforeseen or unforeseeable that has happened since the date that that financial order was made, which has changed the value of the assets so significantly that the financial order can no longer be considered fair to both parties. If an asset that's taken into consideration when the final order was made had been valued correctly at the time and subsequently changes value due to natural price fluctuation, this is not significant enough to appeal the original order, and certainly not out of time. The financial crash of 2008 was not considered to be a barter event by the court, and it is therefore relatively unlikely that most situations in relation to COVID would be considered a barter event. The question that a court will ask when looking at this is whether or not an event was unforeseeable. If COVID itself and the lockdown that followed was unforeseeable, what about the effects of it, such as price fluctuations? Are they viewed by the court as foreseeable? Establishing whether or not an event is a barter event, and therefore whether or not a final financial order can be appealed, is really fact specific, and it's important to get specialist legal advice on your particular situation. It's not something that we can answer with particular certainty today. But financial loss as a result of COVID and the prohibitions on property sales and things like that aren't necessarily going to reopen final financial orders because they've applied to all property transactions. It is worth bearing in mind that successful applications in relation to what the court considers barter events are really, really rare, because the court can always exercise discretion in whether or not to set aside the order. So I think the pre-submitted question about that was about bearing a final financial order because of the implications that COVID had on that person's ability to work and pass their driving test. The short answer is it is highly unlikely that you're going to be able to vary that order. But by all means, you know, the family law company offer free half hours. We can give you some more specific advice with some more details about your situation, but probably the answer will be no. Right, without further ado, I'm going to hand back to Imran, who is going to talk to us a bit more about some children matters that arise regarding holiday contact, appeals, things like that.
Thank you, Han. One of the questions from Samantha is quite topical, because what we are experiencing during these times of COVID are significant delays with court hearings. They're being put off, the courts aren't operating at full capacity. And so what I want to try and do is share with you some tips about how to manage that and what you can do in this situation. So if I just answer Samantha's question, if your hearing was postponed because of COVID, when will the courts resume? It depends on what kind of court hearing it is. If it's a final hearing, for example, the courts will treat those as priority. If it's, say, a directions hearing, so one of the earlier ones, sadly, it's going to be a case of waiting to see when the courts can next accommodate that hearing. The courts are operating on the basis of the more serious the risk to the child, the more urgent a case has to be heard if it's been adjourned. So what I would suggest in your case, Samantha, is to get on the court and perhaps nag them to say it's been adjourned. When is it going to be relisted? I've just mentioned that there are significant delays with court hearings, and that's primarily due to the courts operating at full capacity. It's getting better, and the reason it's getting better is because the courts are embracing technology. And by technology, many of you will be aware or maybe have experience of court hearings being over the phone, or perhaps more recently over video. And by video, the two main sources are over Teams, which is free, and also over something called CVP, which is the court's own internal video way of setting up court hearings. Again, that's free. There aren't many attended hearings. Those are the ones where you have to go into court, and that's again because of social distancing, capacity numbers, risks, etc. But if you fall into the group of, say, someone who doesn't have good connection, or someone who requires an interpreter, or there are extreme allegations of domestic abuse that you are trying to present to the court, then those kind of scenarios are ones where a court will be mindful of allowing you to go into court. And those become what we call hybrid. So part remote, where someone's being patched in via video, and partly attended. But let me give you some tips about how to manage these delays and what to do when you're waiting around for the next court hearing. Well, the overwhelming tip is to still comply with deadlines. If you've been asked to do a statement, make sure you do it on time. If there's a problem, maybe you're ill or you've got childcare problems, the court's going to be sympathetic to that. So what you would need to do in that situation is to make an application to the court. So if it's a children case and there are existing proceedings, it's on a form called a C2. If it's another form of proceedings, so non-molestation orders, it's on another general application. The courts will be sympathetic to that. A tip that I give parents who are in the same scenario, and there are many who I represent, and indeed children who I represent who are going through this, is to still try to isolate them from court proceedings. They're bound to be suffering through lack of what they would normally do during these COVID times, but what they don't need to know is about how these court proceedings are being extended, because that's only going to compound to them feeling frustrated. That's going to compound to their anxiety. That will then reverberate onto your anxiety. So try to avoid that if you can. One of the best tips I can give you is to make the most of the court hearings when you actually have them. So typically, make sure that you do some practice sessions on the video links with Teams before the hearing starts up. because you only have limited time during these court proceedings. Now, they are really strict on how long you will have in terms of court time. So make sure you do some tests before you do that. When you have the chance to go to court, make sure you remember to get everything you need. So if there's a statement that you think will be necessary, make a note of that before you go into the court hearing. If you are talking about contact and your hearing is in, say, May, and you think there's not going to be another court hearing until September, deal with the summer holidays. So make the most of the limited time that you've got, all right? When it comes to appeals, those haven't really been affected by lockdown. Again, the rules are the rules. So just by way of brief reminder, if you have a final order or a final decision about something, you've got 14 days pretty much, and those timings are pretty strict. If you are delayed in appealing, you can ask for permission to appeal out of time. And that's where you would explain to the court why you need a bit more time, why your appeal was late. So in terms of those aspects, appealing, those rules haven't changed during lockdown. And the courts probably will give you a bit of leeway if, for example, you had to self-isolate, so you couldn't access legal advice, which is a good reason to ask for permission to appeal out of time. So my overwhelming advice is to still comply with deadlines. Nag the court when you are not hearing from the court about your court hearings, but also make the most of the time when your opportunity arises. One of the things that we all want to do is to go on holiday. And I'm in that boat. But one of the issues that we tend to get asked, perhaps just before Easter and before the summer holidays, is how do I deal with holiday arrangements if I've got problems with the other parent? I'm going to try and answer this in two ways: holiday arrangements during normal times and holiday arrangements during COVID times. But the law is the law, and it hasn't changed no matter what time you are looking to go on holiday. If the other parent or carer has parental responsibility for your child, you need the written permission from that other carer to take your child abroad. Okay, that's the law. There are some exceptions. If you have a court order saying a child lives with you under a child arrangements order, or previously known as a residence order, then you can go abroad for a month without the need of the other's written consent. If you are a guardian, a special guardian particularly, then that period is 3 months without the need for the other parental responsibility holder's written consent. So a lot of people forget that, but don't forget to use that. I still would recommend that you share your plans with the other carer or parent. My advice when it comes to holiday arrangements is to not leave it to the last minute. It is best to give as much notice as you can. Let the other parent know when you are planning on holiday. Let the other parent know where you are going. Let them know what dates you'll be away from. Because the reason you do that is that the other parent's going to want to know that their child's safe. And actually, if you are open, it's more likely to get the other parent on board if you are in a relationship with the other parent where you are on civil terms. Let me just contrast that with COVID times. The law's the law, like I've said, that hasn't changed. But many parents are asking us, well, can I go abroad now? And what are the risks from a health perspective if I go abroad now? There is so much uncertainty when it comes to going abroad that my advice is to avoid going abroad now. Without trying to get too political, there isn't a planned review until April about the possibility of going abroad. And even then, there's going to be a list of countries that will be red listed, which means that you will have to quarantine. Those lists change. And it's actually going to be very difficult for you to fix on a country that you want to go abroad. So my advice for now is to look at staying within England and Wales. You have to check their regulations as well. When it comes to booking holidays and sorting those, let me give you some general tips for COVID times and non-COVID times. First thing is, like I've said, be open with the other parent or carer. Tell them in advance. Try to give them as much notice as they can. Try to also avoid booking holidays which you know will clash with their dates of contact or their holiday dates. If you want to go abroad, they're more likely to not agree it if they know it's coinciding with their holiday. I get asked the question, well, if the other person's not going to agree to me going abroad, what can I do? Well, it's a serious criminal offence if you go abroad without the written consent of every other person, parental responsibility holder. It's an offence under the Child Abduction Act. That's a criminal offence. We don't want to be in that situation. But if you can't get agreement from the other parent, what do? You have to apply to the court for permission to go abroad. And the procedure does slightly vary if you've got a court order already. But essentially, in the absence of any agreement, you have to ask the court. So let me give you some tips about what to do in that situation. The first thing is, don't leave your application to the last minute. The courts are already, as I've said, inundated, backlogged, and they're not going to treat a request to go on holiday as a priority. Do it months in advance. Doing it months in advance actually helps convince the court that you've actually really thought about it, particularly if you've given them, the other parent, some more notice. When looking at holiday requests, a court's going to think about the kind of country you're going to go to. And some of you may be familiar with the Hague Convention, which is essentially a group of countries who signed up to an agreement making it easier to return a child if they are held unlawfully in that other country. That's going to be a key criteria. The other thing a court's going to think of is, and this comes to the COVID times, what country are you thinking of going to? What are the risks there? What are the risks from your child? Does he or she have any health risks? Do you or your partner or the people caring for your child have any health risks? That's going to be a relevant factor. The court can put into place some safeguards. For example, it can ask a parent to pay a lump sum into court to cover any legal costs if that child's returned to a non-Hague Convention country. So perhaps a more problematic country in terms of maybe being in the middle of or close to a war zone or having civil unrest. That comes back to my point about the choice of country. The court's going to look at the choice of country very carefully. The court can deal with the surrendering of passports, if you like. The court can order the parent going abroad to surrender their passport at the local embassy. Does that country have an embassy? Or the court can order, like I've said, a bond to be paid into a court in England to cover any legal costs from the other carer to recover that child. So the court's going to look at safeguarding your child, when looking at any potential holiday proposals. But like I've said, the perhaps overwhelming advice is to not leave it to the last minute. That applies to no matter what time you are thinking of going on holiday. To try and get the parent, the other parent or carer involved, let them know. To not leave it to the last minute in terms of applying to court. And certainly in terms of COVID times, I would avoid going abroad at this moment in time, because you have the additional problem of the changing of the countries that are okay. Another problem that you're going to have is the need to quarantine. That's a two-way thing. You might have to quarantine in the country you are going to, and might have to quarantine when you get back. So that's going to have an impact on the other parent's contact, if they are having it. If that parent has a court order saying he or she can have contact, then you may be in breach of complying with that order. And like Hannah mentioned in her talk earlier on, that could lead to potential enforcement proceedings against you, where you could be asked to pay a fine, do unpaid work, or in worst case scenario, and I stress worst case scenario, could be committed to prison. So we want to avoid that. On top of that, you're going to have problems with the child not being able to go to school. I mean, I know we've been pretty glad, some of us have, to have our children back in school, but they won't be able to do that if they have to quarantine. So that's my advice when it comes to holiday arrangements. So what I'm going to do now is I'm going to hand back to Farah, who's going to just lead us into the Q&A. Thank you.
Thank you very much, Imran. That was really helpful, and Hannah too, for covering all those topic areas during your presentation. There have been quite a few questions that have come in on the chat that I know that Imran and Hannah have been trying to respond to when they can, but there are also a few other questions in the Q&A that have come up. So please do continue to add your questions if you have some, but we're just now going to go into over the next few minutes, just answering some of those questions as well. And Imran and Hannah are going to try and pick out some of the questions that have come up and answer live if they can. So Imran, if I hand back over to you, would that be all right?
Sure. I've had a question here, and I think it leads into my last area of talk, and I'll just read it out. What is reasonable time that the other parent should provide the dates when they want to see a child for holidays, non-custodian? Well, I think what that means is the other parent's not the primary care of that child. What's a reasonable amount of notice? It's a good question. It does depend on the circumstances. I've had situations where it's been through significant family events, and so of course you're not going to have as much notice there, but we're looking at months rather than weeks. So for summer you'd be looking at probably March, April time at the very least, before now is probably the best time to look to propose those arrangements. When it comes to Christmas, you're looking at probably September, October. So we're looking at about 3 months on average. There is no hard and fast rule. Sometimes it may not be possible to give that much notice depending on your work commitments. Some people have quite inflexible jobs. So as much notice as you can, but at least a couple of months. If I just pause and just see if there's a question that Hannah wanted to.
Thanks, Imran. So I've got a question here about mediation, which is a really helpful tool to discuss child arrangements orders if, conversations between yourself and the other parent are becoming a little tense and difficult, but neither of you want to go down Sari. But I will just say that the court is quite a blunt instrument, and it might come up with a solution that neither of you are happy with. Whereas if you can talk things through and agree between yourselves, hopefully you'll get something that is more suited to your children and is better for you both and better for your child. The court generally have a principle that actually it's not going to make any orders in relation to children unless it is absolutely necessary. This is common sense, really, if you think about it, because children change and grow, and what type of arrangement and order might be suitable for your 2-year-old isn't necessarily going to work for them so well when they're 10 years old. And if you don't have a court order in place that you are therefore legally obliged to comply with, you have more flexibility in deciding how your children should spend time with you as they grow older and their needs and their wishes change. Anyway, that was a little intro to this question. Back to the question. This person would like to go to mediation with my husband to resolve a number of issues pertaining to our 3 children. Can I force him to do this? Unfortunately not. Before you issue a court application, if that's what you decide you need to do to resolve the issues, you will have to have spoken to a mediator yourself and obtained a form from them called a MyAM form, which you will need to include with your court application. And as part of that process, the mediator will speak to you and call your husband to ask them to come to mediation and try to talk things through. Mediators are really good, and if they can see that you're completely at loggerheads and nothing can be resolved, they're not just going to keep doing mediation sessions with you. They will say, actually, this isn't working. You probably need to find a different way to resolve this. But it is a great starting place to have a neutral third party to help you see each other's point of view. So, go to mediation if you can, but you can't force somebody to do it, unfortunately. I'm going to hand back over to Imran and see if he's got another question.
Thank you, Han. I just had a question here. Can a child go abroad to see the other parent where the borders are closed? Would it be essential travel? That probably wouldn't be essential travel. That's because the government has allowed for changes to the normal rules, the stay-at-home rules, for movement between households within the UK. Going abroad to see another parent would not be allowed under those rules. However, if the proposed person you were seeing was unwell, God forbid they were passing away, then that might be allowed as an exception to the rule. And that's the kind of thing you'd have to complete on the declaration form. So the answer to that is probably, as a general theme, is no. Another question that I've had is, this person's middle son is due to have an operation abroad, a planned one. They've had 6 there before, and the GP, perhaps understandably, said it's better to finish that treatment abroad. This person has two kids, 7 and 8, and you have to take them with them because you're a single mother. Will it be okay if we all have only one letter from the hospital? And I'm not sure the part about the reference to the middle son. There's 2 issues there. The first thing is, of course, you would need the permission of the children's other parent in written form. That's the first thing. If you had a letter from the hospital, which probably will only cover the treatment for the one who needs it, that will help. But then what I would do in that situation is you'd have to complete on the declaration form that it is essential for you all to go because you are the primary carer. So that's what I would do in that situation. I'll just deal with this last one that's coming whilst before I hand back to Hannah. This anonymous person's son's father doesn't tell them any information about their son when they are in his care. They don't know if he's having medication or food or how he slept. So quite understandably, this person doesn't have that much trust. Would this person be within their rights to say no to a holiday until they can approve his ability to converse responsibly? Well, let me just deal with that. There's a couple of issues inbuilt in that. The first thing is something which we haven't talked about, called parental responsibility, and that is the ability for each primary carer to make day-to-day decisions for that child. It is not required for each parent to tell the other parent things for day-to-day things. So, for example, what time they woke up, have they done their homework? That's not required because a court would trust that carer to look after the child while he or she is in their care. When it comes to more significant issues, such as medication, then that is a reasonable requirement to be shared. And I would think that that should be shared. When it comes to holidays, let's think about it from the child's perspective. If that child is looking forward to go on holiday, how would he or she think or feel if they were not able to do that? Would that mean that the person, the other parent, would perhaps get the wrong end of an unhappy child? And would that go anywhere to actually improve the trust and communication? My suggestion would be that it probably have the opposite effect. It would make conversation, dialogue, perhaps less likely because that child has ultimately been stopped from going abroad. So I probably don't see the two as being linked, but the point about sharing of day-to-day information is important, particularly when it comes to medication, but other day-to-day issues such as meal times, how they've ate, how they've slept, is not required to be shared. I'm going to hand back to Hannah and then she'll take over for a few minutes. Thank you.
Some great questions, and I've had some more questions in that I'm going to answer for you now. This one is quite interesting. Somebody has asked, at what age does a child have the right to say no to a child contact arrangement, and dad won't listen to the child's wishes? Now, one of the factors that a court look at when making a decision in relation to children is their wishes and feelings. When a court is making a court order, their paramount concern is the welfare of the child. And to consider the welfare of the child, they look at the following factors. Their ascertainable wishes and feelings in light of their age and understanding, their physical, emotional, and educational needs, the effect of any change of circumstances on the child, the child's age, sex, background, and any characteristics that the court consider relevant, any harm that the child is at risk of suffering, and how capable each of the parents are to look after the child. And then the court also looks at the range of powers that are available to it to make orders in relation to the child. So At any age, the child's wishes and feelings can be asked, providing that they can articulate those and speak. But the court don't really put a huge amount of weight onto a child's wishes and feelings until, I would say, end of primary school, start of secondary school. It does depend on each child because, different children have different levels of emotional maturity and emotional intelligence. So, you might have a very young 8-year-old and actually quite a mature 8-year-old that can better understand perhaps the consequences of what they're saying. If they're saying, I don't want to see this parent as much, or I want to live with that parent, the court will want to make sure that a child really understands that. And actually, children are children, and the parent should be making the decision jointly for the benefit of the child. The child should never be made to feel the burden of responsibility of deciding where they should live or how much contact they should have. So saying from about the age of 13, a court will put a lot of weight on a child's wishes and feelings. And then by about the age of 16, if a child is saying that they don't want to see a parent, the court isn't going to force them to do that. Practically, it's very difficult to force a 16-year-old to do anything. So their hands are tied a little bit in that respect. But, if you've got a 7, 8, 9-year-old saying very clearly that they want contact to change in a particular way for reasonable reasons, that would be taken into account if court proceedings were issued. If this person in question has a contact order in place, then the appropriate thing to do would be to apply to court to vary the order and say, look, this is what my child is saying, this is why I think it needs to be varied, dad's not listening, and take it from there. And the court can order a report by CAFCAS. CAFCAS are the Court Advisory and Child Safeguarding Service, and CAFCAS can do a special report called a Wishes and Feelings report, where they would go and speak to the child within a school setting or a neutral setting to try to find out what they really want away from the influences of any parent. It is worth bearing in mind that children are often people pleasers, so they might say one thing to one parent and one thing to another parent because they think that's what their parent wants to hear, which may or may not be true. So that is just something to bear in mind as well. Another question that I've had come in, which is quite interesting, is about putting an ex-partner on a birth certificate. This person has said that their ex-partner hasn't been present or interested throughout the whole pregnancy. So if he's not on the birth certificate, what rights will he have or be able to get? Now, if you aren't married and the father isn't on the birth certificate, he does not have parental responsibility. And Imran's obviously just helpfully explained for us what parental responsibility is. He can apply for it. And the first stage in him applying for it would probably be for the court to order a DNA test to prove that the child is his, and then he can apply for parental responsibility. And in most cases, he would be given parental responsibility. However, if he's had no interest in the child at all, and you don't put him on the birth certificate, then that means that he will have no rights to information about the health and education of the child, and it will be very much up to him to kind of go through the court process or ask you to give him that information. His rights to the child will not be automatic. If you are married and he is the father of the child, then the father will get parental responsibility automatically, whether or not he's on the birth certificate. Right. There was another question that came in and I cannot see it right now. So I'm going to hand back over to Imran while I find my question.
Thank you, Hannah. I'm just wondering from Farah if we've got time just to answer the last one.
Yes, absolutely. You do. We have about kind of 5 minutes or about 5 minutes that left to answer some questions.
Great, thank you very much. Okay, this question's again quite a common one. What's an appropriate level of initial contact during COVID for a parent who's never had contact and is now looking to start? And also, are there any recommendations about how to manage introductions of people to babies? Okay, there's two issues there. First of all, slow and sure is the best way to deal with that situation. The child's pace is going to be the barometer, the way you measure that. So I would initially have suggested that it probably should be supervised. It's a young child there, so you'll be looking at a formal supervised contact center, somewhere where the child can get used to the other parent, somewhere where the other parent can get used to the child. That might be even more relevant if the child has any special needs. So I'd be looking at supervised contact. Children at that age, sometimes it's actually better to have quite regular contact because they have no concept of time. So you'd be looking at least weekly, perhaps fortnightly, depending on who can pay the costs of those contact centers. When it comes to contact centers, there's usually a referral fee, and then there is the price per session. I'd probably recommend supervised contacts, first of all, and then once the child begins to get accustomed to the other parent, and when the other parent gets used to the child, you can drop it down to something called supported, which is rather than one-to-one supervision, where someone's generally around within the confines of a contact center. So I'd be looking at that kind of package and arrangement to start off with. When it comes to introductions, again, with contact centers that Hannah and I work with, they usually have what we call pre-contact meetings, where they will meet with the parents beforehand. They'll also meet with the child or children beforehand. They can actually facilitate those introductions. So again, taking you out of it might be easier because you're leaving it in the hand of someone neutral. And also it's going to be quite hard for an introduction for you because that child is naturally going to be attached to you. And that's a credit to you because that child is going to want to gravitate naturally towards his parent. You could, if you wanted to, perhaps do some life story work. So some pictures of the dad, maybe invite him via a mutual friend to send him some pictures of his family. So you can introduce the concept of the other parent. So that's what I do in that situation. I think that probably brings us to all of the questions that we've had. Can I say thank you very much to everyone for joining us today. Thank you very much for all of your questions. I found them really insightful. I hope we've covered them. Can I now just again thank Farah and her team at Gingerbread for inviting Hannah and myself to join us. It's been a privilege for us to be able to work with such a great charity. And so without further ado, thank you again from Hannah and myself, and I'm going to hand back to Farah. Thank you.
Thank you very much, Imran. So I hope that you've all found that session really helpful. I know we weren't able to answer all the questions that came in. It's fantastic that there was so many questions that you all had. And just a big thank you to Imran and Hannah for supporting us to help answer some of those questions. Like I said earlier, we are going to try if we can to have a look at some of those questions and see if there's any way that the Gingerbread team might be able to support separately by signposting to some useful information for you where we can. We will also be sending out an email following this session with just a recording of the session and also a link to some feedback. This is the first webinar that we have done as an advice session. It would be fantastic to be able to get a clearer understanding of how you have found it and whether it has been a useful session for you. So we do have a very short feedback questionnaire, which my colleague Mary will be able to post into the comment section for you. If you could just complete that, it should take less than 5 minutes really to complete. We'll also be sending a link to that in the email that will be shared after the session. And finally, just to say that we hope to be able to support with providing additional webinars in the future. This session was free and we hope that you found it very useful. All of our advice and information services are offered for free to ensure that single parents get the advice and support that they need. If you'd like to support us in delivering our services, please do consider making a donation towards our services, and a link will be posted in the chat session as well. Really, that's it from me. Thank you very much again for attending the session, and we really hope that you found it useful. Thank you.